Hello dear students, I welcome you to class 10 of my series of online talks. Now we have seen so far as to what this American realism movement was about, and we have covered the heads that we were supposed to cover as part of our syllabus. As I had said in my last class, that in my next talk I'll try and very quickly give you a quick summary of all that we have discussed so far in American realism. So we had seen while starting our discussion about American realism is the fact that American realism was not a school of law, it was a movement. Why? Because they never had a conception of their own as regards what the law is. Rather, they insisted upon the reality not being ignored, and the reality being, according to them, is that certainty in law as claimed by positivists is not achieved by merely reducing law into text, law into black and white, and that when it comes to actual interpretation of the same black letter law, much of its meaning is actually dependent upon how the judge who is going to interpret it is actually going to interpret it, meaning thereby the individual motivations of individual judges play a very important role in eventually deciding the meaning of any given black letter law. And therefore Justice Oliver Wendell Holmes, the leading protagonist of this movement, argued that you give me any proposition of law and give me a set of facts, I'll apply the same law to write the judgment from both sides. And this, in a way, clearly shows the extent to which the interpretation of given black letter law is judge-centric, and that is why they called it reality, and that's why the movement is referred to as realism. We have seen that that American realism movement is actually to be seen in two distinct concepts. One is rule skepticism, the other is fact skepticism. In rule skepticism, we have seen that it deals with the central argument of American realists, which is that the black letter law does not produce certainty, and that's why skepticism for the claim of certainty of rules, and therefore this movement arguing that much of it is actually dependent upon which individual motivation of an individual judge actually impacts the actual decision of a judge, and it is not there lying to be discovered from the black letter law itself. So this movement was known as rule skepticism, and primarily led by the likes of Oliver Wendell Holmes, and later on carried forward by B.A.L.B. Another movement associated with American realism is that of fact skepticism. What is fact skepticism? In fact skepticism, it is first of all highlighting the fact that courts, judges, apart from performing the role of interpreters of law, also perform the role of fact-finding institutions, in the sense that facts, what actually happened, is to be first proven before the court. So therefore facts are to be established before the court, and only then the law is to be applied on the given set of facts. And primarily led by Jerome Frank, a trial court judge himself, he argued that that American realist movement, by concentrating only on the phenomenon of rule skepticism, has actually ignored a very important function of the courts, which is to ascertain facts. And he said that when it comes to ascertaining facts, that is also not free from any skepticism, in the sense that many a times ascertainment of fact is dependent upon how the judge or the jury is actually going to weigh the evidences which are being presented before it, and it is not something which is clearly dictated by the rules of law and precedent, and that much of it is actually dependent upon how the judge or the jury is actually going to view, and what is the kind of weightage that the judge or the jury in a given case is going to ascribe to a particular witness or to a particular document which is produced before it as evidence. And therefore fact skepticism movement also insisted that this is also something which needs to look into, and we need to improve the performance of the court as a fact ascertaining organ as well, upon which the black letter law eventually is to be applied and interpreted. So this is a very, very important contribution coming from Jerome Frank, leading the movement of fact skepticism. Now, American realists, though they argue that black letter law does not produce certainty, but their argument is not just limited to exposing the fallacy of the claim of certainty. They are also, as claimed by Jerome Frank, they are constructive skeptics. They want to ensure, even rule skeptics wants to ensure that by simply closing our eyes to reality, we are actually taking away the element of predictability from law, because predictability in law is not there because of the fact that the law exists in black and white. And now that we know that the discretion of the judge plays a very important role in actually shaping, in actually giving meaning to what the law is, so therefore we need to talk about the actual motivations which a judge should actually make use of in order to arrive at a particular meaning to be ascribed to the black letter laws that he or she is actually interpreting. And if we close our eyes to this reality of discretion which a judge possesses when it comes to giving meaning to the black letter law, we are actually allowing a complete free hand to judges to decide a case whichever way they want. And if that is the case, probably we do not have the right to criticize a judge for having not decided a case in the manner in which it should have been, because if black letter law does not produce certainty, and there is no discussion as to what are the motivations and what are the reasons which should actually influence a judge in deciding a particular case, then we do not have any locus to criticize a judgment because of the fact that it is not propelling the cause of truth and justice. And therefore realists wanted that for we to be actually discussing the real motivations which should influence a decision of the judge, we must first get rid of this notion that certainty is there because we have laws in black and white. So that is the starting point for us to actually enter into a debate about the possible motivations which a judge must take into account while delivering the judgment. Now, this argument of rule skeptics was actually taken forward by a very important rule skeptic in the form of Carl Levlin, another American scholar who actually attempted his energies in trying to address the possible motivations and possible inclinations which a judge must have in order to exercise the discretion that he possesses because of the task of interpretation that he or she has to perform. And in this respect, therefore, he argues that we must understand that even adjudication is a process wherein law is actually in flux, and therefore this transition is happening wherein law is continuously being shaped. And this is very important because this shaping of law must answer the problems of times in which we are living. So therefore this dynamism also needs to be addressed through the means of adjudication. And most importantly, he says law is a tool to further social ends. And this furthering of social ends, because of now that we know that the element of discretion exists in the realm of adjudication, this furthering of social end is something which a judge must also take into account as the guiding principle for his or her interpretation of the black letter law. What he or she must keep in mind is the fact that he is supposed to achieve those social ends through the means of law. So though exercising discretion, not caged and confined by the black letter law, but the judge must keep in mind that the law that he or she is interpreting has a particular social objective to attain, and therefore the interpretation that he is placing upon it must be the one which furthers that cause of desirable social end to which that law was actually directed. Another very important point that he makes is that we must understand, we must try and understand law, comprehend law in narrower categories. Because of our obsession with principles and black letter law, we tend to have a very general understanding of the different concepts of law. The fact remains that any given set of principle and law will have a very different meaning in a given set of facts, and therefore we need to have a narrower understanding of these concepts in relation to particular facts in which those principles or laws were to be applied, rather than having a very broader understanding of the very principles. So this is a very important contribution coming from Carl Levlin. Now another important facet of realism is the fact that when you enter into this debate as to what are the factors which a judge must take into account while exercising his discretion, and then you say that furthering social end is the most desirable guiding principle which a judge must take into account while interpreting laws, it interestingly also brings the question of drawing the boundaries of adjudicatory role, especially in the backdrop of the constitutional doctrine of separation of powers. Where to draw the line? Now, this furthering of social end via the means of adjudication has happened tremendously in India through the means of what we know as the public interest litigation, wherein we know that through public interest litigation the cause of marginalized have been highlighted, have been mainstream, have been in a way expedited by the courts in India, but the same is also labeled as examples of judicial overreach by the executive and the legislature. And therefore this furthering of social end through the means of adjudication is not without controversy and debate, especially because of this argument that doing so violates the constitutional doctrine of separation of powers. But herein what we must also understand is the fact that once it is admitted that certainty is not achieved by having laws in black and white, what is being argued that eventually the answers, the interpretations have to be brought from the realm of ought. Now, if you are still arguing about separation of power being relevant, knowing that black letter law does not produce certainty, what is actually being claimed is that there is a line to be drawn for adjudicatory function even in the realm of ought, beyond which judges cannot travel, because beyond which is the domain of the executive and the legislature. So furthering social ends is fine, but only that much which is within the permissible limits for adjudication, and that the cause of furthering social ends cannot be extended to such an extent wherein all governmental functions also become part of the adjudicatory function. And this is an important point to argue, because despite the fact that through the means of public interest litigation, courts in India may appear to have actually ventured into the realm of policy and by realm of governmental function, but they nevertheless keep on insisting upon the fact that policy questions are not the domain of adjudication, and it is only the principles which are actually the justification for legal rights are the domain of courts. What they have actually done is that they have construed rights rather liberally, and thereby enabling them to enter into a territory which was traditionally understood not to be the territory of adjudication. But this very liberal reading of the rights has enabled courts to actually claim more space into the otherwise governmental domain. Now, but this the court has been very consciously doing it, not by rejecting the argument that there is no line in the realm of ought meant for courts to abide by, but by actually delineating a wider boundary for individual rights. And in this backdrop, if you look at the example of Article 21, reading of several socio-economic rights and basic human needs like right to shelter, right to food, right to health, being part of Article 21, invariably extends the boundary of right into a territory which was otherwise not considered to be the territory of courts. But what is important to note is that the courts have done that not by rejecting the fact that all governmental functions also form part of adjudication, but by actually extending the boundaries of fundamental rights flowing from Article 21. So they have done probably something which was not permissible, but they have still not rejected the theoretical narrative which both sides quote in order to make their respective points. And therefore, this is an interesting question to actually grapple with. Now, finally, I have discussed the fact that how American realism has actually contributed in devising a new means of research which is directed towards predicting the judicial outcomes based on the study of judges and courts as a whole. And the first one, wherein the primary purpose is to actually predict the decision of a particular judge before whom a particular case is lying for adjudication. Now, if that judge's judgments delivered in the past can actually be examined, scholars argue that based on an actual examination, real examination of the judgment delivered by a particular judge in the past, one can actually find out the real hidden motivations which actually propel that individual judge in delivering his or her verdicts. And based on that assessment, it is actually possible to predict the possible outcome of the pending cases before that particular judge. Second is an associated concept related with this is that of jurimetrics, wherein the idea of predicting the judicial outcome has been extended from individual judge finding individual judges' motivation to that of judges as a whole. So a group behavior of a particular court's judges are actually studied so as to find out as to what is the possibility in percentage terms of a particular judgment being delivered if a particular kind of matter actually comes up before the court. And therein I have referred to the papers from Professor Tarunab Khetan and a paper, another paper by three scholars who are trying to ascertain the group behavior of the Supreme Court judges in relation to specific issues. So this is what in nutshell I have discussed so far in American realism, and hope I could instill some curiosity in you in relation to the functions of judicial process. We'll carry on this discussion further in our coming classes as well. So that is it so far as a brief summary of what we have discussed so far in American realism is concerned. I really hope that you take whatever that we have discussed forward and read some of the papers that I have discussed and referred to in my talks so far. So I would want you to read the paper written by Upendra Bakshi, Situating Dworkin in New Delhi, and its reply by Professor Dworkin, both articles being published in the International Journal of Constitutional Law. I would also want you to read the two papers which I referred to in my talk on jurimetrics. I would want you to read what the modern day writers like Anuj Bhuwania has to say in his book, Courting the People, Public Interest Litigation before the Supreme Court of India. He is also an NLS Bangalore graduate and presently teaching in Department of Law and Governance in Ambedkar University, Delhi. You should also read comments by Gautam Bhatia on what he believes is the actual role of courts and especially Gautam Bhatia's views on public interest litigation, so as to have a holistic account of what these discussions are actually about. And only if you concentrate and try and comprehend the various nuances of this debate, that you'll be in a position to have your own point of view. So thank you very much. If you have any questions and observations to make, please feel free to write to me at manvendradnlu@gmail.com. Hope to see you again soon. Thank you very much.